Dr. Mann was a Canberra surgeon who had sued the ACT government. That dispute ended up at trial, but it settled after the first day, with a $400,000 settlement paid by the government. Dr. Mann was furious, and he wrote to another member of the ACT Legislative Assembly, stating that the management of the case had been a waste of taxpayer funds. That local member forwarded those criticisms to the Chief Minister of the ACT, Kate Carnell. She then forwarded to the local member an outline of how the case had progressed and copies of legal advice to the ACT government about the progress of the case. Her intention was to show that the government had acted in accordance with proper legal advice. Dr. Mann found out that this had happened, and he sought discovery of those pieces of legal advice because he was concerned that he may have been defamed. Now, normally, advice received by a party, in this case the ACT government, from their legal advisors is considered to be confidential, and there is a privilege against any requirement to show it to others. However, this privilege may be lost in a number of ways, including by disclosing the advice to a third party. Essentially, by disclosing the advice to a third party, the client is saying, I no longer want to keep this information confidential because I've just disclosed it to someone else. Therefore, I can no longer claim privilege. In this case, though, it was all a bit complicated because Chief Minister Carnell had disclosed the advice, but to someone else in the Legislative Assembly. Was this considered to be third-party disclosure? The High Court said no. The majority judges said disclosure by a client of confidential legal advice received by the client, which may be for the purpose of explaining or justifying the client's actions, will waive privilege if such disclosure is inconsistent with the confidentiality which the privilege serves to protect. There was nothing inconsistent with that purpose in the Chief Minister conveying the terms of that advice on a confidential basis to a member of the Legislative Assembly who wished to consider the reasonableness of the conduct of the Territory. From this case, we learn that client confidentiality can be waived by disclosure to a third party, but only if the disclosure is inconsistent with the purpose of the privilege.